Hello everyone. Today I am going to discuss a course on business law and industrial law. The course code is BUS 504. Today we will discuss here what is contract, what are the requirements of contract, all agreements are not contracts, all obligations also don't constitute contracts, essential elements of a valid contract, classification of contracts. So, what is contract? Contract can be defined as an agreement creating and defining obligations between the parties. So, it's an agreement which creates and defines obligations between the two parties. Every agreement and promise enforceable at law is a contract. So, we can say that any agreement that can be enforceable at law is a contract. Requirement of a contract. A contract requires two parties. There must be two parties to constitute a contract. An agreement. A contract requires an agreement. An agreement is constituted by means of an offer and a binding acceptance of the offer. An obligation. An obligation is the legal duty to do or abstain from doing something. An agreement to a contract should give rise to some legal obligation, that is, obligation which is enforceable at law. All agreements are not contracts. Agreements in which the intention to create legal obligation is absent are not contracts. Therefore, agreements relating to social matters are not contracts. For example, an agreement between two persons to go together for a walk or a cinema show doesn't create any legal obligation on their party to abide by it. All obligations also don't constitute contracts. A domestic arrangement with no intention to create legal binding relations will not constitute a contract, such as a promise by a father to pay pocket money to his son. Paying the pocket money to his son is an obligation, but it is not a contract. Essential elements of a valid contract. The following are the essential elements of a valid contract. The first one is agreement, that is, proposal and acceptance. And then intention to create legal relationship. Lawful consideration. Competent parties. Free consent. Not expressly declared void by law. Certainty and possibility of performance. Compliance with legal formalities. Classification of contracts. Now we are going to see the details definition of all the classifications. Contracts may be classified as follows. On the basis of enforceability, there are some types of contracts: valid contracts, void contracts, voidable contracts, illegal contracts, unenforceable contracts. Classification of contracts on the basis of mode of creation: express contracts, implied contracts. And if we classify the contracts on the basis of extent of execution, there are two types of contracts: executed contracts, executory contracts. And on the basis of form of contract, there are two types of contract: formal contracts, simple contracts. So what is valid contracts? Contracts which satisfy all the essentials of a valid contract is laid down in the law are termed as valid contracts. Only valid contracts are enforceable in a court of law. What is void contracts? An agreement may be enforceable at the time when it was entered into, but later on, due to certain reasons, for example, impossibility or illegality of the contract, it may become void and unenforceable. Such contracts are called void contracts. What is voidable contract? An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of other or others, is a voidable contract. Agreements induced by coercion, undue influence, fraud, or misrepresentation are voidable at the option of the parties whose consent has been so obtained. What is illegal agreements? An agreement is illegal when it is in contravention of a statutory provision. Unenforceable contracts. Certain contracts become void because they can't be enforced due to certain technical defects, as for example, that is non-observance of legal formalities of writing, registration, etc. These contracts are valid in the eyes of law, but since they are incapable of proof, law courts will not enforce them. Many of the contracts in the absence of writing are quite good, but can't be enforced in a court of law until the written evidence is furnished. Classification of contracts on the basis of mode of creation. Express contracts. Express contracts can be defined that contracts entered into between the parties by words spoken or written are termed as express contracts. In such contracts, parties make oral or written declaration of their intentions and of the terms of the transaction. Implied contracts. Contracts which come into existence on account of the conduct and acts of the parties are termed as implied contracts. For example, if a person takes a seat in a bus, his act shows that he has entered into an implied contract that he will pay the specified fare to the bus owner for taking him to his destination. Classification of contracts on the basis of extent of execution. Executed contracts. When both the parties to the contract have fulfilled their respective obligations, contract is said to be executed. Executory contract. When one or both the parties to the contract have still to perform certain things in future, the contract is termed as an executory contract. For example, A agrees to sell a radio set to B for taka 200. B pays the price in advance. The contract is executed as regards B, but executory as regards A, for he is yet to deliver the radio set to B. Classification of contracts on the basis of form. Formal contracts. Contracts under seal and contracts of record have been recognized as formal contracts under English law. Their validity depends upon their form alone. Consideration is not necessary for such contracts. They are required to satisfy certain legal formalities in order to be valid and binding. Simple contracts. All contracts other than formal contracts are known as simple contracts. They will be valid only when they are supported by consideration. Thank you. If you have any query, you can add a comment in the comment section.